Divorce is not fun, so anything that can make the process a little less traumatic, hostile, and costly is a positive. That is why the court requires divorcing couples in Michigan to engage in mediation prior to a trial. Mediation can help couples make decisions about custody, parenting time, child support, property division, or spousal support and alimony. Similarly, some counties provide mediation services through Friend of the Court, or FOC, to help families grappling with custody decisions to reach decisions that will help them avoid lengthy and expensive court trials. What is mediation, you may ask? Divorce mediation is a process designed to encourage and help spouses reach an agreement on as many issues as possible involved in ending the marriage. In divorce mediation, a third-party neutral, often an attorney with specialized training, helps facilitate a conversation with the spouses and their attorneys to help them work through disputed issues with the hope that they can agree on some or all of the disputes between them. The mediator will listen to each spouse's concerns, wishes, and points of views. Often using shuttle diplomacy, that is, meeting with each side separately and going back and forth between them, the mediator will try to bring the spouses closer together on disputed issues until an agreement may be reached. While the mediator may be a lawyer, he or she cannot be your lawyer or your spouse's lawyer. They cannot and should not offer legal advice, nor should they advocate on behalf of either spouse. Importantly, mediators also cannot force two parties to agree or impose solutions on them. Each party must voluntarily agree to any agreement reached. Additionally, discussions or conversations and offers during mediation are confidential and cannot be used in further proceedings if the mediation does not result in an agreement and court intervention is necessary. Here's the key to divorce mediation. It takes two to tango. Both parties have to want to participate in mediation for it to have a chance to work. Both parties have to be civil, rational, and open to compromise. If either spouse is unable or unwilling to work together, mediation will likely not end in an agreement. But if you and your spouse approach mediation as an opportunity to determine your own outcomes, you will reap the benefits of this alternative to trial. The outcome is more cost-effective than trial and allows more creativity in crafting a resolution than if a judge imposes a solution. The Friend of the Court, or FOC, is a division of the circuit court system in Michigan that assists families with custody, parenting time, and support issues. Like mediation, the FOC in many counties serves as a resource for both the court and the parties to help achieve mutually agreeable resolutions to disputed child-related issues. The FOC's services can include conducting investigations and making recommendations to the court regarding child custody, parenting time, and support matters. This is done by interviewing parents, reviewing records, and sometimes speaking with the children. Based on its findings, the FOC makes recommendations to the court. As with the judge's decision regarding issues involving children, the FOC is required to consider the best interests of the child in any recommendations made. While the FOC's recommendations are not binding until ordered by the judge, they carry significant weight in court. If either party disagrees, they can file an objection, which must name the specific areas of dispute and a legal basis for the dispute, which then prompts a court hearing to resolve the issue. Mediation and the Friend of the Court may complement each other in Michigan divorces. Depending on your county's local procedural rules, couples may begin with mediation to resolve disputes. Other counties may have FOC provide assistance with custody issues and the use of mediation for property issues. If mediation fails or only partially resolves issues, the FOC may step in to provide further assistance on child-related issues. Additionally, the FOC may refer couples to mediation if it believes the disputes may be resolved without judicial intervention. This dual approach allows for both collaborative and structured problem solving, ensuring that divorcing couples have multiple avenues to resolve conflicts. Remember this: if you and your spouse are able to negotiate your divorce, Using mediation or other alternative dispute resolution methods, you will retain more control over the final outcome and avoid the negative and often long-lasting effects of trial. For more information or to answer specific questions about your case, contact Kreis Enderle to schedule your consultation today.